the establishment of a constituent assembly and its effort in making Indian constitution. In this class, we will discuss the salient features of Indian constitutions. The Constitution of India was framed after the in-depth study of many challenges and problems like poverty, illiteracy, deprivation, inequalities based on caste, creed, sex and religion. The constitution of any country is the supreme law of the land. It lays down the basic structure of the government. It defines the powers, functions and responsibilities of each organ of the government. Therefore, it is considered to be the basis of the government of the country. Since the Constitution of India stands superior, all the laws enacted by the legislature has to be in conformity with the Constitution. Constitution of India was created by a constituent assembly and not by the Parliament of India. Thus, the Parliament cannot override the Constitution. You know that on 26th November 1949, the document was adopted and finally it came into force on 26th January 1950. Every written constitution in the world has its own unique characteristics. Indian constitution is not an exception to it. It has many prominent features that distinguishes it from the other constitutions. These distinguished characters are called salient features of the Indian constitutions. They are lengthiest written constitution. Secondly, it has preamble. Then it has fundamental rights, directive principles of the state policy. It has fundamental duties. It provides for parliamentary form of government. A federation with a strong centralized tendency and a unique blend of rigidity and flexibility of the constitution. Judicial review, universal adult suffrage, single citizenship and finally independent judiciary. One more that is secularism. These are all salient features of Indian constitution. Let us discuss one by one the salient features of Indian constitution. First one is the Constitution of India is one of the lengthiest constitution in the world. The Constitution of USA has 7 articles, whereas Indian Constitution at the time of commencement it contained 395 articles divided into 22 parts and 8 schedules. Now it consists of totally 470 articles or divided into 25 parts and it consists of 12 schedules. The constitution became lengthy mainly due to the following reasons. It follows a British parliamentary form of government with bicameral legislature. It embodies some fundamental rights which are similar to the Bill of Rights declared by the United States Constitutions. It elaborates a set of directive principles of state policy as does the Irish Constitution. Second reason for the lengthiest constitution is India is a federal state in which detailed list dividing up powers between central and state governments like union list, state list and concurrent list. And residual powers of the legislature remains with the central government which is similar to that of Canadian Constitution. But in USA and Australia, residuary powers in the domain of the states. It deals with the structure and organization of not only the central government but also of the state government. The Government of India Act 1935 was in operation when India got independence, and this act was a voluminous document, and its incorporation has naturally made the constitution bulky. India is a country of great diversity. It is the country of several minorities like religions, languages, caste, race, creed, etc. It consists of provision for the protection of interest of religious and linguistic minorities. It consists provisions relating to official languages, government service, electoral machinery, etc. In fact, in other countries, these matters are usually left to be regulated by the ordinary law enacted by the legislature. It also contains a detailed provision relating to citizenship. Second salient features of Indian Constitution is the preamble. While the US Constitution deals only with the federal government and leaves the states to drop their own constitution, but Indian Constitution provides for both the union and states with the same fullness and precision. Preamble reflects the basic structure and spirit of the Constitution. It represents the entire Constitution in written words. Preamble to the Constitution embodies the fundamental values and the philosophy on which the Constitution is based. It describes the source, nature, ideology, goals and objectives of the Constitution. Preamble describes India as a sovereign, socialist, secular, democratic, republic country, and it underlines the national objectives of social justice, economic justice and political justice as well as fraternity. It emphasizes the dignity of the individual and unity and integrity of the nation. It declares that in India the people are sovereign. That means preamble highlights the type of society we have. It serves as a channelized tool for the interpretation of the Constitution. The words socialist and secular were inserted by the 42nd Amendment of the Constitution. The same amendment contributed to the changes of the words unity of the nation into unity and integrity of the nation. The significance of the preamble of Indian Constitution lies in the "We the people of India." These words emphasizes that ultimately powers are vested in the hands of the people. Objectives of the preamble. The preamble focusing on four main objectives, that is equality, justice, fraternity and liberty. Equality implies to equal opportunity for all and one. Justice ensures fair judgment in the field of politics, society and economy. Fraternity aims in maintaining the integrity and strength of the country along with individual dignity. Liberty assures every citizen of India has freedom of speech and expression and religious independence. In Beriberi case, court held that preamble was not a part of the Indian Constitution. But in Keshwananda Bharati case, Supreme Court held that preamble to be a part of the Constitution and the Constitution must be read in the light of the preamble. In S.R. Bommai case, Supreme Court held that preamble of the Constitution is an integral part of the Constitution. In Indira Gandhi versus Raj Narayan case, Supreme Court held that preamble to the Constitution guarantees equality of status and opportunity. and as well as rule of law is the basic structure of the constitution. In Indira Sani case, Supreme Court held that preamble to the constitution emphasizes the principle of equality as a basic structure of our constitution. In I.R. Coelho versus State of Tamil Nadu case, Supreme Court held that alter in any way the original preamble of the constitution is a violation of the basic structure of constitution. Incorporation of fundamental rights is another salient feature of the Indian constitution. There is no democratic constitution worthy of its name without fundamental rights. Fundamental rights are the basic rights conferred to the citizens of the nation by the constitution. Generally, fundamental rights set out the rights of individuals and responsibilities of the government and government agencies. Fundamental rights are incorporated in Articles 12 to 35 under Part 3 of the Indian Constitution. If these rights are violated by the state or anyone else, the individual has a right to approach the Supreme Court or High Court. These rights are qualified rights and are not absolute in nature. That means we should enjoy the fundamental rights subject to reasonable restrictions. Some of the rights are available only to citizens of India, while others are available to all the persons. For example, Article 15 Class 3, Article 16 Class 1, Class 4 and Article 29 and 30 are available only to the citizens of India. Other than that, all other fundamental rights are extended or available to the persons irrespective of the citizen of India but not to the alien enemies. These guaranteed rights fall under following broad categories, that is right to equality from Article 14 to 18, right to freedom Article 19 to 22, right against exploitation, that is Article 23 and 24, right to freedom of religion, that is Article 25 to 28, cultural and educational right to minorities from Article 29 to 30. Recently, by 86th Amendment Act, right to education has been included in the list of fundamental rights as a part of right to freedom by adding Article 21 capital A in the Constitution. Next salient feature of Indian Constitution is the Directive Principles of State Policy. Directive Principles of a State Policies are enumerated in the Part 4th of the Indian Constitution, that is from Articles 36 to 51. Unlike fundamental rights, directive principles of the state policies could not be made enforceable by any court. But nevertheless, directive principles of the state policies are fundamental in the governance of the country. They are the guidelines and supposed to be considered by the union and state government while framing any laws and policies. Directive principles of the state policy lay down certain social, economic and political objectives to achieve the ideal true democracy. Over a period of time, many directive principles have attained the status of fundamental rights either by the amendments to the Constitution or by judicial interpretation. Another salient feature of Indian Constitution is fundamental duties. Originally, the Constitution of India did not contain fundamental duties, and these duties have been incorporated in the Constitution to remind every citizen that they should not only conscious of their rights but also of their duties. Fundamental duties are defined as moral obligations. That means these are all moral obligations of all citizens to help to promote a spirit of patriotism and also to uphold the unity of India. There is no legal sanction for violation of fundamental duties. There is no legal sanction for the violation of fundamental duties or non-performance of fundamental duties. The 42nd Constitution Amendment Act 1976 has incorporated 10 fundamental duties in Article 51A of the Constitution of India. The 86th Constitution Amendment Act 2002 has added one more fundamental duty. As a result, now there are 11 fundamental duties. These duties are important and necessary for vital interest of our country. Constitution of India provides for parliamentary form of government both at the center and in the states. Parliamentary government is also known as cabinet government. It also sometimes called parliamentary democracy. In parliamentary system of government, executive is created out of legislature and is accountable to the legislature. Another important feature of parliamentary system of government is there is two types of executives. One is real executive and another is nominal executive. President is the nominal executive and chief executive powers of the nation are formally vested in his name. The president should always act in accordance with the aid and advice of the Council of Ministers headed by the Prime Minister. Prime Minister is the real executive who exercises all the executive powers of Union. Minister act both as legislature as well as head of the government department. There is fusion between legislative and executive in a parliamentary form of government. The parliament exercises continuous control over the working of the Council of Ministers. The leader of majority party in the parliament, that is in Lok Sabha, is always appointed as the Prime Ministers and all ministers are essentially members of the parliament. A federation with strong centralized tendency is another salient feature of Indian Constitution. The Constitution provides for federal form of government at state and center. The distribution of power in Indian federal system has made the strong central basis. Means Parliament can unilaterally create a new state and it can also alter, modify the territory of any state and even change the name of any state. There are certain provisions in the Constitution which empowers Parliament to legislate even on the subject matters which are enumerated under the state list. Constitution of India has expressly and explicitly established the doctrine of judicial review in several articles such as Article 13, 32, 131, 2, 136 and Article 143 and finally Article 226 and 227. Article 32 of Indian Constitution is the most important article, without which the constitution would be a nullity. It is the soul of constitution and the very heart of it. Under Article 352 and 353 of the Constitution, powers can only be exercised by the President of India, and it requires the approval of both the houses of the Parliament. These provisions make the Indian Constitution both unitary as well as the federal, according to the requirements of the time and circumstances. In normal times, it is framed to work as a federal system, but in times of war, it is so designed to work as a unitary system. Dr. KSOU has described the Indian government characterized as a federal state with unitary spirit. A unique blend of rigidity and flexibility is also one of the basic characteristic feature of Indian Constitution. Constitutions are sometimes classified into flexible or rigid. A flexible constitution is one in which amendment can be made rather easily as enacting an ordinary law. A rigid constitution is one in which an amendment is more elaborate and difficult than that of enactment of ordinary legislation. The process of amendment under Indian Constitution is concerned is both flexible as well as rigid. Some provisions of the Constitution can be amended by the simple majority procedure as is followed for enacting ordinary laws, while the rest of the Constitution is amended by a special procedure that is more difficult and technical, which requires special majority, that is 2/3 majority of vote who are sitting and present in both the houses of the Parliament, and in some circumstances special majority including ratification by at least half of the state legislatures. Judicial review is one more salient feature of Indian Constitution. The judiciary plays a very important role as a protector of the constitutional values, and judicial review is a great weapon in the hands of the court, which implies limited government. The fundamental object of the judicial review is to determine the unconstitutionality of the legislative acts. Universal adult suffrage. It is also one of the basic feature of Indian Constitution. Right of the people to vote and elect their representative is called franchise. India has adopted adult suffrage. That means every citizen attained the age of 18 years or above has a right to vote without any discrimination. Article 326 as amended by the Constitution, that is 61st Amendment Act 1988, lowered the voting age from 21 to 18 years. Through this right, a citizen can take part in the process of formation of the government. Single citizenship. In federation, normally there is double citizenship. In USA, every citizen besides being citizen of United States of America is the citizen of the state in which he or she resides. Independent judiciary is one of the salient features of Indian Constitution. The independence of judiciary means every judge is totally free to adjudicate the matters brought before him in accordance with his perception of the facts and comprehension of the law, without any influence, inducement, pressure, either directly or indirectly from any angle. Secularism. A secular state is neither religious nor irreligious or anti-religious. Rather, it is neutral in matters of religion. India is a country of several religions, and each individual has a fundamental right to practice, profess and propagate any religion as he likes. In India, there is no state religion, means it does not have an official state religion, and state-owned educational institutions cannot impart religious instructions. In matters relating to religion, the state is neutral and non-interfering. It does not promote any religion. The word secular was not present originally in the preamble. It was added by the 42nd Constitutional Amendment Act in 1976. From above discussion, you can know the following are the features of Indian secularism. The state should not have any religion of its own. All the religions shall have equally protected by the state. Free exercise of right to freedom of religion. State shall not discriminate against any particular religion. It means state shall not prefer, favor or disfavor any particular religion. That means religious tolerance. Dear students, I hope that you understood the concept of salient features of Indian Constitution, that is fundamental rights, fundamental duties and directive principles of the state policy, secularism and so on. Thank you. Thank you all.